On this episode of Law Weekly, another perspective on electoral reforms, appointment of judges, we talk about the U.S. government reports on human rights in Nigeria as it concerns the Lekki panel. We have the views of a senior advocate of Nigeria, Abiodun Owonikoko, on all of these and other issues. Plus a look at the judiciary worker strike and news just in that the Lagos Judicial panel will resume its sitting on Tuesday, April 13. Hello and welcome to the program. I'm Shola Shieli. Let's begin straight away with our interview segment. My guest, Abiodun Jelili Owonikoko, studied law at the then University of Ife, now Obafemi Awolowo University. He has practiced law for over 30 years. He was conferred with the rank of Senior Advocate of Nigeria in 2010. In this interview, I began with his views on electoral reforms, especially the propriety of shifting the burden to the Independent National Electoral Commission, INEC, to prove the legitimacy of contested election outcomes.
It's a welcome development to hear a jurist of Justice Vivor's caliber coming up at his valedictory sitting with a suggestion that is actually very radical like that. It's not altogether new. I remember when the Justice Waste panel that was set up to propose reforms for the election, this is one of the things they proposed, that the burden of proof should be shifted. But I believe that it was in the context of election proper, not just all disputes. And they can be forgiven because since that time and now, we've had a robust growth of litigation and jurisprudence, what we call pre-election matter, to the extent that now the Constitution itself has even gone ahead to define pre-election matters as distinguished from election petitions. But the same processes were suggested to fast-track either of these areas of election dispute. However, we must appreciate that in pre-election matter, there are some that are essentially issues arising from how political parties run their own affairs, like nomination, which even INEC has no role to play other than to be a recipient of the outcome of their processes. There are some that are within the ambit of INEC's own regulatory powers. The one that concerns all of them is the election proper, where all the political parties and INEC are stakeholders, both the winner and loser and the entity that conducts the election. Even if we are to go into election disputes, it's not all matters that have to do with election dispute, which should come within about 4 different grounds that have to do with INEC. For instance, non-qualification of a candidate has something to do with INEC. If somebody did not attend secondary school and he lied that he did, I don't see how you can transfer that burden on INEC. If somebody alleges that he was validly nominated but unlawfully excluded, there may well be, in that kind of scenario, a proper case for INEC to have the burden. Since the person will have shown that he was validly nominated by his own party, a process in which INEC has no role to play, and then INEC proceeded later to disqualify the person or to exclude him, then INEC should be the party that will have that primary body. If we do this in those kind of situations, certainly there's a chance that we may streamline and make more credible our process of electoral adjudication dispute. But when it comes to election proper, I believe that there are so much of latitude to protect the INEC officials in the conduct of election that seems to embolden some of them to ride roughshod, believing that at the end of the day, you go and prove. I'm sure you are aware of a famous politician, or will I say notorious, who used to advise his colleagues that whatever it takes, win the election for, let your opponent go to court and prove otherwise. Now, that is practically impossible to happen without some form of support from INEC, because none of the processes is under the control of the candidate. Sure. Even your agents at election posts, their job is that of observer. They don't have a pivotal role to play. So in those situations, especially where, for instance, you start seeing 2 candidates producing 2 different sets of results, both of them certified by INEC, like we saw play out in Imo, which eventually led to somebody that came forth emerging the governor at the end of the day. So we need to pick and choose in what area is it appropriate for INEC to be saddled with the primary burden of proof, and in what other areas should litigants who make a case in court be made to live through the normal principle of he who asserts.
What do you suggest?
We need to pick out those parts of the electioneering process that are primarily the responsibility of INEC.
And then saddle INEC with the
responsibility. Because INEC will normally not be the party that will go to court. So the first principle that he who asserts must prove may not necessarily apply in those cases, even though INEC is a defendant. Once there are two results, the two parties should not have anything to do yet until INEC leads evidence first. And it's not new in our jurisprudence. It is totality of who has the burden of proof that will lead to determination of the case, that determines who starts a case first, not necessarily who the person that went to court. So I think we have to pick and choose based on the facts and the issues that parties are likely to join before we decide on transferring the primary burden of proof on INEC in certain cases, but not in all cases.
You talked also about internal democracy of parties and how candidates emerge. What reforms would you suggest for dealing with that? Because like you rightly said, that has nothing to do with INEC. How can we streamline? Because most of the time, that is even the cases that flood the courts more than election petitions.
But I'll tell you that that actually is not a matter of law.
Okay.
It's a matter of acculturation. What is our culture of politics in Nigeria? A zero-sum game where the stakes are so high, people are willing to risk everything to ensure they don't lose out. That cannot come from just legislation. It has to come from attitude of politicians themselves. And even the electorate, some of whom participate in as delegates at election. When we start to prioritize quality of candidate, integrity, and the fact that when we undermine even the primary process of election at the party level, we are indirectly undermining the eventual outcome of the election itself. So political parties have to invest more in political education. In the interval between election, what should happen is political education, manifesto development, policy formulation that will put them in good stead when the election time comes to put up a formidable program that can win them the heart of the ordinary electorate who are not necessarily members of their party. If you look at the big parties, the same problem that drives one politician from one party to another is what they go to confront in the other party, whether it's godfatherism, whether it's money politics, whether it's politics of lack of integrity or principles. It cuts across. So that's why what is more important, it should start with those lower level of political and community organizations. If we develop at that level, culture of democracy, PTA, in other climes, to contest for parent association position in a school, you have to have a good name in that community.
Sure.
You understand? So when you have started that, where you cannot just come and impose it because you are the richest man in the community, you now become parent association chairman, when your personal lifestyle does not commend you to be a role model. By the time you start having to do all of that at that level and graduate to the state level, the attitude will change. Some people will just always self-disqualify themselves, knowing that the stakes are too high in terms of integrity for them to show interest. And they will then know that merely throwing money at electorate will not do.
Apart from these suggestions that you've given us, generally, a lot of people think that the courts are now the ones that are determining and picking the candidates, because there's an election petition or there are issues with election and you go to court, and you talked about the man who is governor now, who came forth. And a lot of people say that might not necessarily reflect the wishes of the people. I mean, there was somebody who came first, who came second, and the man who is fourth is now governor. And so people wonder, are we ever going to see a time when it's not the courts that is determining who becomes governor or holds political office?
I think I need to correct an impression. The court can never determine who wins an election unless somebody approaches the court to set up a case that is controverted, thereby leaving it to the court to decide which of the pendulum the victory should swing. Where you have a disciplined political class, even in the US, there are matters that political class don't allow to go to court for 20-25 years because they would rather find a grand compromise among themselves than have the court make a final pronouncement that will seal their fate. American presidents, for example, don't test the limit of their power too much, except perhaps for Trump. There are things they just leave to be moot, so that they can use executive orders and things like that to dance around issues that are not too clear, gray areas. But in Nigeria, because of the zero-sum game of politics that we play, somebody who has gone to raise about 5 billion naira to contest senatorial election, an office that even for the 4 years is not likely to earn maybe 1 billion naira as legitimate income. There's no way he will throw in the towel when he doesn't believe actually that the process has been free and fair. So when that happens, what we have seen is that it creates a lot of pressure on the court system. And that's why I, as a person, if I had my way, we should be striving towards having less and less of election petitions. There have been instances across the world where even when political parties have difference about election, they have grand understanding to say, let this person do his 4 years. And next time when election comes, the other party will just practically allow that other party to bring up his own candidate. And that way they start developing a level of trust amongst each other and mutual respect. At the end of the day, when you look at what we invest in election disputes, these are the resources available to even address the needs of the society. It's a dysfunctional system.
Let's move on to another topical issue, the issue of appointment of judges and the caliber of people who become judges. It's become very topical lately, especially against the background of comments made by the NBA president, when he attended the screening of some judges. What are your thoughts about that debate?
To be honest, I think the system in the last few decades, since the civilian came back to power, has been politicized because the Constitution allows it. You can't become a judge without the governor of a state constitutionally, legitimately playing a role. And the politicians have misread that role to mean that they are to influence appointments to reflect their own interest.
So politics has crept in.
So politics has crept in. Even when the rigorous process of appointments, which is there in the NJC rules, are so that only the best will emerge among the successful candidates. At the end of it all, the ultimate appointments still have a lot to do with the State House of Assembly or National Assembly, and then the executive head of government. You remember there was time we had about almost for 12 months nominees to Supreme Court. They had submitted their nomination to the presidency and nothing happened.
Yes.
In normal times, some of them probably in the 1 year period they are waiting, we have had to go to Supreme Court and spend 6 months and retire. Some of them might have been recommended. I am happy that it didn't happen in this case. Some might have been recommended for appointment, and because of seeming slowness in the presidency, by the time they are due to be officially sworn in, they are already past retirement age. And the reason some of them are sent there is because they have cognitive experience that they can bring to bear and share with their colleagues. Appellate courts are not one-man courts. They are courts, of divided, of diverse panel. So they all rub on each other. Somebody is coming from a background of maritime practice. He became a high court judge. He was at the federal high court. By the time he gets court of appeal, he alone will not decide a maritime case. Somebody who has been all his life landlord judge, who was from a state, will be part of it. So he brings his own specialized knowledge to assist and enrich the judgment that they come up with. So I think that we should not misunderstand powers given to us as being conferred for personal aggrandizement. Because there's nothing wrong, for instance, in giving a governor a final say in appointment, in the belief that he's going to exercise that power in accordance with his oath of office to fear or favor no manner of men, regardless of your color, tribe, religion.
I also want to get your thoughts about this recent report of the U.S. Department of State's 2020 country report on human rights practices, especially the comments as it relates to the Lekki shootings. Have you formed any thoughts about it, or what are your thoughts about it?
I'm involved in the proceedings at the panel.
Which is why I'm interested in hearing.
Although it's not a court, it's also entitled to all the respect. Being a body that is charged with receiving evidence and forming an opinion that might be acted upon. From the side that I represent.
Your counsel to Lagos State Government.
Yes. That report, based on what's available to us, did not come as a surprise. You see, we've been on this now for about 5-6 months. We are still waiting for that smoking gun that would lead us to probably change our view about whether something untoward was done by Lagos State Government or even by the federal government. When people loosely use words like massacre, they can be forgiven if they are not lawyers, if they are not learned. But when you look at the international definition of things like that, genocide, you must meet the threshold when the time comes to prove the case. And when you start having independent bodies turning in their own report, suggesting otherwise, then I think people should be open-minded about what eventually may be the outcome of the sitting.
The Judiciary Staff Union, Judicial, made good their threat to resume their suspended strike over issues concerning the financial autonomy of the judiciary. They stormed the courts across the country to ensure that the industrial action was successful. We have the recap of all of that up next.
We begin in Lagos, where we monitored activities at some of the federal and state courts. Members of staff of the Federal High Court, Ikoyi, had arrived at their offices, some as early as 7 a.m. and had settled in for what they thought would be a normal working day. At about 9 a.m., the union members arrived and immediately directed the workers to pack up and leave the court premises. They went round to ensure that everyone had been evicted, after which they sealed some of the offices, locked the gates and pasted notices indicating the commencement of the strike. At the Court of Appeal, Judiciary on Lagos Island, the gates were also locked and no workers were in sight. This was the same scenario at the Lagos High Court next door, indicating also that the strike was effective. At the Commercial Division of the State High Court at the Tafawa Balewa Square, we again observed members of the Judicial Staff Union dispersing the court workers and locking up the offices. The representative of the union, who spoke to Law Weekly, says they have given the government enough time to comply with the provisions of the Constitution, court judgments and other instruments, which re-emphasizes the financial autonomy of the judiciary, which is the main issue behind this industrial action.
Section 121, subsection 3 particularly, which says that all the money accrued to the judiciary must be handed over to the head of courts. And that is the provision which I believe the government ought to comply with. In addition to that, in 2014, we were in court. We got the judgment of court to the effect that all the money accrued to the judiciary in Nigeria should be handed over to the head of court from the federation accounts. So up to now, since that time, don't forget, we've been on strike before. It was suspended because of the intervention of stakeholders and people. Everybody was saying we should just suspend for the negotiation to take place, which we, of course, because we are civil, we allow it to happen.
In Ogun State, the strike was also effective in all the federal and state courts. In Abeokuta, the state capital, judiciary workers stayed away. The implication of this was the suspected criminals who were brought to court could not be heard. In Kwara State, the gates of the courts were also under lock and key. In Ilorin, the state capital, members of the union could be seen enforcing compliance of the industrial action. The Judicial chairman in the state, Ibrahim Sambo, says the strike will continue as long as the state executives refuse to implement the financial autonomy of the judiciary.
The effect of our independence is going to allow the courts to be run effectively and efficiently. Without the autonomy, it's hindering a lot of the activities of the courts.
Activities at the state and federal high courts in Kaduna State are also grounded as a result of the industrial action. Some of the litigants whose cases were up for hearing left disappointed. The chairman of the union in the state reaffirms their commitment not to suspend the strike until the state government implements the financial autonomy to the judiciary.
Judiciary is the only arm of government that sells the arbitration between both the two arms of government. But we are not well financial independence doing our work. And saboteurs of that things, it is the governors of Nigeria.
This same sentiment was echoed in Taraba, Plateau and Yobe states, where the federal, state as well as the Sharia courts were also under lock and key.
The system is collapsing, and we are appealing that This system should be fixed because it is a place where a common man comes and get justice. And where there is no justice, in fact, that society will be in chaos. And that is our problem.
There is a general circular dated on 22nd March that no any state branch or chapter should enter a negotiation unless the national headquarters.
This was the scene at the State High Court in Uyo when our crew visited. Members of the Judiciary Staff Union staged a protest at the court located along Wellington-Bassey Way. They also prevented lawyers, litigants and any other person from gaining access to the court premises.
We want to press home our demand for the full implementation of judicial autonomy, financial autonomy and independence for judiciary.
In Bayelsa State, the strike is also effective and the executive member of the staff union are fully on ground at the courts to ensure total compliance.
Until government says, yes, you people come and take this one, you take our freedom by force, so it is our freedom. So we want to take our freedom.
Empty car parks, locked gates with security operatives on guard, and that was the situation at the Federal High Court in Abuja when we monitored the industrial action. The ever-busy FCT High Court and the National Industrial Court suffered the same fate as both places are deserted. It's a similar situation at the Court of Appeal and the Supreme Court as workers meal around the gates while officials of the union monitor compliance.
It was a suspended strike in 2014-2015. We had this strike, and it's all issue of independency of the judiciary, Section 121, to be obeyed by the governor. It's a constitutional matter in which the governors of this country swore to uphold and to obey.
In May 2020, President Muhammadu Buhari had signed into law an executive order granting financial autonomy to the legislature and the judiciary across the 36 states of the Federation. The Executive Order Number 10 of 2020 made it mandatory for all states to include the allocations of both the legislature and the judiciary in the first-line charge of their budgets. The order also mandates the Accountant General of the Federation to deduct from source the amount due to the state legislatures and judiciaries from the monthly allocation to each state for states that refuse to grant such autonomy but the states are not complying. Meanwhile, the Nigeria Bar Association and the Chief Justice of Nigeria, Justice Ibrahim Tanko Mohammed, have intervened and pleaded with the judiciary workers to stop the strike and explore other solutions. So far, these interventions have not worked. The NBA has condemned what it described as the silence of the federal government over the matter. The association has also resolved to embark on meetings with other stakeholders, particularly the state governors and representatives of the federal government, to find a solution to the problem. While these discussions continue, the Judiciary Staff Union says the strike continues until the demand for the implementation of the financial autonomy of the judiciary is met.
And we round off with a report that the Lagos Judicial Panel on Restitution for Victims of SARS and other related matters will resume its sitting on Tuesday, April 13th. The panel had taken a short break for the Easter holidays. Before the break, the panel got an extension to sit for another 3 months. This means that the panel will now sit beyond the initial April 19 deadline, with a new deadline fixed for July 19. An infographic obtained by Law Weekly from the Secretariat of the panel shows that since it commenced sitting on October 26th, the panel has sat for 65 days, during which time it partly heard 112 cases out of the 235 cases it received overall. 123 cases remain unheard. A further breakdown shows that there are 14 cases relating to the Lekki Tollgate incident, none of which has been concluded. The panel has, however, concluded 12 cases with rulings and recommendations made. 1 case has been adjourned sine die, 4 cases withdrawn, 9 cases were struck out for lack of diligent prosecution, 5 cases have been adjourned for adoption, and another 3 cases have been adopted and reserved for judgment, recommendation, and award. Compensation has also been awarded in 7 cases, with the panel handing out checks totaling 43.75 million naira. And that's our program this week. Don't forget that you can find these and past episodes of the program on our YouTube page. I'm Shola Shieli. Thank you for watching and see you next week.